Thank you very much for joining us today for our annual Dunson Constitution Day lecture. The Constitution Day lecture series is named in honor of Professor Linton Dunson. Professor Dunson was the founder of the Department of Government here at Wofford and an inspiration to a generation of students. He was a particularly thoughtful scholar of American political history and deeply read in the literature of the American founding. Well known for his encyclopedic knowledge of our nation's political development, he embodied the intellectual passion that defines our program today. And I think it's fitting that the series be named in his honor. The annual Linton Dunson Constitution Day lecture series also owes a great deal to two enterprising Wofford alumni, Josh Whitley and John Lennon. Josh Whitley is a founding partner in the Smith Whitley Law Firm in Charleston, South Carolina. He's a Phi Beta Kappa graduate of Wofford College and a current trustee for both Wofford College and the College of William and Mary Law School. We are grateful for his service to the college and his generosity in raising the funds to endow this lecture series. We're also grateful for the help of Johnny Lennon, who is currently special counsel with the legal firm Duffy & Young. Johnny has 30 years of experience representing plaintiffs and defendants in state courts of South Carolina, the United States District Court, the United States Court of Appeals for the Fourth Circuit, and at least one case before the Supreme Court of the United States. He's received numerous distinctions and awards for both his work as a trial lawyer and his extensive civic work, for which he received the Order of the Palmetto from the Governor of the state of South Carolina. Most importantly, he is a Wofford College alumni and continues to serve on our Alumni Advisory Board. Johnny Lennon has graciously agreed to introduce our speaker today, and following the talk, there'll be a question and answer session led by the Honorable Donald Coggins, United States District Judge for the U.S. District of South Carolina, and note cards that were given to you on the way in the door for questions that you might have, and there'll be students in the aisles during the question and answer session that will collect them for you. Thank you very much.
The reason I'm here is I had Dr. Dunson for 5 courses when I was at Wofford. And William, I calculated roughly the number of law graduates from UofSC with the Wofford graduates taught by Dr. Dunson. Wofford enrolls more students at the University of South Carolina Law School other than Clemson and UofSC, and has over the years. And I might add, if we did some statistics, I think of the undergraduates, we might be second or even first group. So anyhow, before I introduce William, I want you to know he had a choice. He could be in Rome, Italy today at the American College of Trial Lawyers annual meeting and then headed off to London, or he could come to Scarborough, South Carolina. There's a man who has values. I thought the best way that I could introduce William Hubbard was to think about in 1970, he's having a conversation with his guidance counselor as he's finishing high school. And he's setting forth his ambitions, goals. And she says, dream, William, dream. And now these two chairs of William Hubbard coming back to report 52 years later to that high school guidance counselor. This is what he would report. He goes to the University of South Carolina, graduates Magna Carta, is deeply involved in all sorts of student affairs. South Carolina, just like Wofford, awards the Algernon City Sullivan Award to one student, a student that the faculty and the administration agree has demonstrated academic excellence, but more than that, leadership, courage, conviction, a person who's going to make a mark in life. 3,000 students, William, in your class, something like that. William Hubbard was the award winner. He then goes to law school to distinguish himself. He realizes realizes that one important thing is to associate yourself with accomplished people and to learn from them. So he gets one of the most prestigious law clerks existing in South Carolina, to the Honorable Robert Chapman, United States District Court Judge, later a Fourth Circuit Court of Appeals Judge. And yes, Judge Chapman holds an honorary degree from Electoral College. So after that, William joins Dunson Mullins. At the time it was Greer and Scarborough. 13, 14, 15 lawyers. It was the biggest firm in the state. But William had demonstrated to them, first, learn your craft. Become an excellent lawyer, whether you're a trial lawyer or a transaction lawyer. But when you have leadership abilities that will transcend law, you're going to be able to contribute more than the representation of clients. And so William distinguished himself as a trial lawyer. He became a member of the American Board of Trial Advocates, restricted to no more than 5% of the lawyers. He also became a fellow in the American College of Trial Lawyers. Only 1% of the bar can be a member of that group. And in South Carolina, it's never been more than 0.5%. So after distinguishing himself and really concurrent with that, he's involved in all sorts of civic affairs. He loved the University of South Carolina, so he became a trustee at a young age. He continued in that role until he became chairman of the board at the University of South Carolina. I guess other than Cabby and his children, the University of South Carolina is his next love. And he's devoted his life to it. But now let me try to move on real fast because David said I only got 3 minutes. So William gets involved in the American Bar Association. He's president of the Young Lawyers Division. He's deeply involved in it on an ongoing basis. While he's still a member of the Board of Trustees, he doesn't have to apply for leadership positions. People are drawn to him. They see that he solves problems. He's using his law practice, his training for the betterment of the public, for the betterment of society. Later, he becomes president of the American Bar Association. He is the only South Carolina leaning in the history of the American Bar to be his president. He so distinguished himself in his leadership role there that they endowed the William Hubbard Fund in his honor for those contributions. That was in 2015. And if you think a guy from Florence, South Carolina, happens to be the 800th anniversary of the Magna Carta, the Great Charter, William gets in his desk an envelope that size. It's an invitation from the Queen Elizabeth to be America's representative at Runnymede to celebrate the 800th anniversary. And I believe a separate letter to say, Mr. Hubbard, would you consider escorting Princess Anne to the official event? That's pretty big stuff for somebody from Florence, South Carolina. Since then, William was back in private practice at Nelson Mullins, some international practice now, devoting a lot of his time to public service. The South Carolina School of Law physical plant had been in poor shape. It was 20 years overdue being replaced. It's now been replaced. There's no physical facility any better in the country. But his standing was not that great. National rankings had gone down. William could have taken positions with international law firms, with lobbying firms. He could have made $5 million a year just for being involved in this. Instead, he said, I'm in love with the university. He became dean in 2020. The rankings have gone up 12 numbers. Only 4 schools in the country have had that advancement during the time that William has been dean. So he's competing with all these others. To tell you the best story of this William's success, the trait that he has most, I wrote him an email 2 nights ago to fact check a couple of things. And I said, William, I want to know school was when you took over and what you've made it today? His answer was this: through the hard work of a brilliant faculty and a dedicated administration, I'm happy to report that we've made these advances. We're one of 4 schools in the country that has done that. Not a word about being the dean, about being the leader, about having all the connections that helped make that possible, including recruiting great faculty. That is a hallmark of William Hubbard. It's not about him. It's about the mission, about the team, and about accomplishing something to make life better for our society. William Hubbard.
Thank you. That was far too generous. Thank you, Johnny. That was really far too generous. Johnny's recitation of the time over in England in 2015 did remind me of one incident in connection with all those festivities. There was a reception at Buckingham Palace, and we went through a receiving line, and certainly the Queen was leading the receiving line. And then they escorted us into a different room. And I was minding my own business, being a good guest, and this tall man walks into the room and says, "Where's the American?" I looked around and I raised my hand, and this tall man walks up to me and he says, "We protected you in the French and Indian War. We tried to tax you for your own protection, and you left us." I think he was kidding. It was Prince Philip. I hope he was kidding. So I'll tell you, Johnny, I would really rather be at Wofford College than in Rome. As beautiful as Rome is, this is a really special place. From the time I first saw it as a high school student, and then the advances that have been made here, it's really spectacular. You're really so fortunate to be here. And I'm honored to speak here today to this wonderful audience of so many bright young students and others here at Wofford. You are blessed, you really are blessed, and you'll appreciate it more later to learn from such outstanding professors on this incredibly beautiful campus. Wofford, I can assure you, has a sterling reputation in academia, and at the University of South Carolina Law, we simply love our Wofford students. They are truly stars at the law school. I agree with that. Mr. President, you're doing a good job, a really good job. Wofford is consistently recognized as one of the best liberal arts colleges in the nation, and I hope as this address unfolds today, you will gain a greater appreciation for the vital importance of a liberal arts education in the preservation of our democracy. So I'm grateful for the opportunity to speak here today in celebration of Constitution Day. And as the name suggests, Constitution Day commemorates the signing of the Constitution on September 17, 1787. The Constitution is indeed the bedrock upon which our country rests. Everyone knows of the Constitution, but far fewer know how the Constitution actually works. Today, I'm going to start with a few basics, and some of you may know all this. You probably know all this, but I think it's important that we return to basics in our country, and I trust it will be clear as we move along that we must always be reminded of the basics, and why we must always remind our fellow citizens of the basic structure and principles of our government. The Constitution, of course, is the framework of our government, and as you know, it consists of a preamble and 7 articles. And the first 3 articles establish the 3 branches of government. Forgive me for being so basic, but it's important that we return to basics. Article 1 establishes the legislative branch, ensuring supremacy of the will of the people, subject to the constraints of the Constitution itself. The Congress passes laws to address specific societal needs or to regulate conduct. Article 2, of course, establishes the executive branch. The President is the head of that branch and is charged with enforcing the laws as passed by Congress. These are the words from the Constitution. He shall take care that the laws be faithfully executed, end quote. Unlike a dictator, the president is constrained to honor the law. In our country, we cherish the concept of rule of law, not law by ruler. Article 2 also sets forth in detail the process of election of the president by way of what is commonly referred to as the Electoral College. The states send the certified votes of their electors to Washington, and I quote, "The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all the certificates, and the votes shall be counted." As then Vice President Pence correctly concluded on January 6, based on the clear words of the Constitution itself, he had no constitutional power to do more than, as the Constitution says, to open the ballots so they could then be counted. Finally, Article 3 of the Constitution establishes the judicial branch, consisting of the Supreme Court and other courts established by Congress. These include the district courts and the appeals courts. And of course, Judge Coggins is one of the federal district courts here in South Carolina. He's a federal district court judge, the trial judge for the federal courts. These three levels of federal courts, district courts, appeals courts, and the Supreme Court interpret both common law and statutory law and examine these laws in relation to the Constitution to make sure that constitutional rights are not violated. This process is called judicial review, and the authority of the Supreme Court as the final arbiter of the law was established in the case of Marbury versus Madison in 1803. The founders intended for the federal courts to be above political influence. They intended to foster judicial independence as fundamental to the preservation of our democracy. That is why federal judges have lifetime appointments. Alexander Hamilton, a man of some modern popularity, placed judicial independence at the top of his list of reasons to take up arms in the American Revolution. He wrote extensively of the importance of judicial independence in the Federalist Papers. More recently, the late Justice Ruth Bader Ginsburg noted that an independent judiciary is essential to the rule of law and stated that judicial independence, quote, can be shattered if the society that the law exists to serve does not take care to ensure its preservation. This three-part or tripartite structure is designed to provide checks and balances upon each branch to prevent one branch from having too much concentration of power. Of course, Article 5 provides the mechanism to amend the Constitution, and the framers intended to make it difficult to amend the Constitution. Amendments to the Constitution must be proposed by 2/3 vote of both houses of Congress or by a convention called by Congress at the request of 2/3 of the state legislatures and then signed into law, or ratified by the legislatures of 3/4 of the states, or by ratifying conventions conducted in 3/4 of the states. You see all the different steps that would be necessary to amend the Constitution. This is so changes to the Constitution can be only made with overwhelming public support. Since our Constitution was created, there have been only 27 amendments. The first 10 of these amendments, as you know, are known as the Bill of Rights, and they were added shortly after the Constitution was created and they were added in 1791. The purpose of the Bill of Rights, as it says to the preamble to the Bill of Rights, is to, quote, prevent misconstruction or abuse of the Constitution's powers and to instill public confidence in the federal government. These amendments are the amendments that guarantee essential rights and civil liberties, such as freedom of speech, religion and assembly, the right to bear arms, the right to a fair trial, freedom from unreasonable searches and seizures, freedom from self-incrimination, and protecting the role of the states in American government. In order to better understand what we've discussed about the Constitution, we need to understand how these fundamental principles came to be. Principles embodied by the Constitution did not come overnight. nor did the founders create them and create this document out of thin air. Rather, philosophers and scholars have considered and developed these principles over about 4,000 years, tracing back to the time of King Hammurabi. King Hammurabi ruled the Babylonian Empire during the 18th century BC, and during his reign he developed the Code of Hammurabi, a set of 282 laws which broadly encompassed all aspects of the Babylonian Empire, including family law, economic law, civil law, and criminal law. The code was inscribed on a stele, S-T-E-L-E, a stone slab, and was placed in public view, which set the precedent that law should be open, accessible to the public, and predictable. Principles of law were further developed by Aristotle. He wrote in the 4th century BC that laws should be laid down well in advance of the cases to which they would be later applied. A principle he believed was the foundation of the law was epikeia, which translates to equity. Again, we see the emergence of principles of just and transparent laws. We also see the emergence of a new principle, equitable dispute resolution, available to the people. These principles are inherent in the document that was most influential to the founders in writing our Constitution. And that document was indeed, Johnny, Magna Carta. Magna Carta, sometimes called the Great Charter, is the foundation for the rule of law and is a symbol of freedom and justice in the United States and all around the world. But how did Magna Carta come to be? In 2015, King John of England met with the English barons to resolve a decades-long conflict between them regarding a series of arbitrary and oppressive taxes and extensive abuses and atrocities by the king against the barons. To prevent war, King John met with the barons on a watery meadow on the banks of the River Thames at a place we now know as Runnymede, which is now near the site of today's Heathrow Airport. Negotiations were tense and fragile. The barons put forth a set of written practical demands and elevated them to a set of principles. King John and the barons eventually struck an agreement, and Magna Carta was sealed. There are 4 copies of the original still in existence, 2 at the British Library in London, another at Lincoln Cathedral, and a 4th at Salisbury Cathedral, all in England. The copy from Lincoln Cathedral traveled to the United States during World War II so that it could be ensured of its safety during the bombing of London during 1940. Magna Carta has exerted its influence on this nation since the British settlers set foot in Virginia. The Charter of Virginia in 1606, drafted pursuant to the influence of the great British jurist Sir Edward Coke, it's spelled Coke, pronounced Cook. So he extended the privileges through his advice, the privileges and liberties of English citizens, English subjects to the inhabitants of Virginia colonies and their descendants. They received the same rights as Englishmen. Coke was a barrister, judge, and Speaker of the House of Commons in England, and he attributed crucial importance to Magna Carta as the basic guarantee of English rights in England, and that was reflected in the laws of the colonies. Thus, the rights of the English people, established by Magna Carta, inured to the colonists through the adoption of English common law by the colonial governments. So at that time, Magna Carta had been essentially ignored for centuries. Coke brought forth Magna Carta as the authority for his opposition to the Stuart kings in England's claims of divine right and royal prerogative. Statutes could be repealed, but Magna Carta was permanent because it enshrined the original liberties that the English people held. It was then that the idea of Magna Carta as a charter of individual freedoms became a reality with lasting political impact. Armed with the writings of Coke and English jurist Sir William Blackstone, who published the first scholarly edition of Magna Carta in 1759, based on those precedents, our founders created the framework for a government where authority flowed directly from the people. So Magna Carta gave rise to our Constitution and the Bill of Rights, and it's the basis of many of our most fundamental concepts of law. It sets forth the revolutionary idea that no person, no sovereign, no king, no prime minister, no president is above the law, a concept now embraced in what we call the rule of law. Not law by rulers and not rule by law. After the decision in Bush versus Gore brought an end to the contested presidential election in 2000, then Justice Breyer noted that there were no riots, no acts of violence, no guns, no deaths. He said this: "We have decided to decide our major disagreements under a system of law. That is a remarkable thing, that people actually follow that. It has a long history," Justice Breyer said, "and that history does begin 800 years ago with Magna Carta." That was indeed true in America until January 6th. As citizens, we must be determined not to lose our tradition of respecting the rule of law and to preserve the peaceful transfer of power. At least as of yesterday, if you Google rule of law, one of the top links directs you to the website of the World Justice Project, a multinational, multidisciplinary initiative to strengthen the rule of law globally. At the World Justice Project's website, you will find this definition: the rule of law is a durable system of laws, institutions, norms, and community commitments that encompasses and delivers 4 universal principles. 1, accountability. Government and its people are held accountable under the law. 2, just laws. Laws are clear, fairly applied, and protect fundamental rights. 3, open government. Governments are transparent in passing laws and administering and enforcing laws. And 4, accessible justice. Justice delivered in a timely manner by fair and independent judges who reflect the communities they serve. History shows us that democratic governments are fragile and often fail. More of them fail than survive, and many of them don't last long at all. Public trust and confidence are essential to the preservation of our democracy. But now there's much political rhetoric that seeks to undermine public trust in elections, in courts, and democratic processes and institutions. If people say the court system is rigged or elections are rigged, without evidence to support those assertions, those statements feed into the public distrust of democratic norms and institutions, and the fabric of our nation becomes frayed. This fragility is reflected in the most recent Rule of Law Index, which is published annually by the World Justice Project. The index is the leading source of original independent data on the rule of law. From 2020 to 2021, the Rule of Law Index showed that among 139 countries covered by the index, 74% declined in constraints on government powers. Stated differently, authoritarianism rose in 74% of the countries around the world, embracing 85% of the world's population. 82% experienced declines in civic space, civic participation, freedom of opinion and expression, and freedom of assembly and association. Additionally, 94% of these countries experienced increased delays in administrative, civil, or criminal proceedings. The United States did not fare any differently. As of 2021, the United States ranked 27th in its strength and adherence to the rule of law, and a decline from its prior ranking of 25th. The United States' adherence to the rule of law dropped 2.9% from 2020 to 2021. Weakened constraints on government powers, increased corruption, less government transparency, and infringements of fundamental rights all factored into this decline. So let's dive deeper into why this may be the case. What exactly is causing the rule of law to falter in the United States. There are gaps in civil justice. There's a lack of access for the basic civil justice needs of 85% of America's poor, based on the latest survey by the Legal Services Corporation. There are fundamental issues in how we administer criminal justice. For example, many accused plead guilty because they can't make bond, and the resulting criminal record constrains their ability to later secure gainful employment. But I submit that a crucial factor in the decline of the rule of law and the decline in confidence in our democracy is our failure to educate people about how our government works. This deficit in knowledge of basic civics is acute. The most recent snapshot of the state of American civic education, created by the Center for American Progress in 2018, paints a disturbing picture. Only 23% of 8th graders performed at or above the proficient level on the National Assessment of Education Progress civics exam. More broadly, consider that recent surveys show that only 26% of Americans can name all 3 branches of government. 1 in 3 Americans cannot name even 1 branch of government. Only 43% of Americans can name a single justice of the Supreme Court. To put these figures in perspective, consider that 69% of Americans can name a judge on American Idol. Perhaps this lack of basic knowledge about our government stems from the fact that more than half of Americans, 54%, between the ages of 16 and 74, read below the 6th grade level. The U.S. ranks 125th in the world for literacy. The rule of law lays the foundation of the liberties we enjoy. If the rule of law continues to falter, our liberties, our very way of life, is at risk. I remember March 26, 2012 very clearly. I was departing the Russell Senate Office Building in Washington after a meeting. I heard the noise. It was coming from the plaza of the U.S. Supreme Court 1 block away. It was the first day of oral arguments to determine the constitutionality of the Patient Protection and Affordable Care Act, commonly referred to by many people as Obamacare. So I heard the noise and I walked over to the plaza to see what was there. There were people of all colors and all ages. They wore every type of clothing, from t-shirts emblazoned with slogans to running gear to suits. There were doctors and medical students in white coats. There were posters and buttons of every size and color. Some people had megaphones and others tried to outshout their opponents. There was even a trumpeter and a trombonist. It was a cacophony and a montage all at once. It was America. Above it all, on the west pediment of the Supreme Court, are the words we know so well: equal justice under law. Those words are the embodiment of the justice that we seek as Americans. Justice fairly applied regardless of class, race, gender, sexual orientation, disability, or station. So having breathed in the fullness of that moment in March, I sought a quiet place. I walked around the magnificent Supreme Court to the east side. No one was there, not a soul. It was eerily calm and quiet. And I looked up at the pediment on the east side of the Supreme Court building, and there above the columns are these words: Justice, the guardian of liberty. All men and women seek liberty and freedom to explore, to learn, to earn, to have a family, to make a difference. Judge Learned Hand is perhaps the greatest American judge not to have served on the Supreme Court of the United States. On May 21st, 1944, just days before the D-Day invasion on the beaches of Normandy, he spoke before thousands in Central Park in New York at the vast I Am an American Day ceremony. This was largely to immigrants to the United States. His remarks were entitled, "The Spirit of Liberty." His remarks touch at the heart of the dangers of a lack of civic knowledge and the faltering of the rule of law. He said this, "Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can save it." He went on, "And what is this liberty that must lie in the hearts of men and women? It is not the ruthless, the unbridled will," he said. "It is not the freedom to do as one likes. That is the denial of liberty and leads straight to its overthrow." He went on, "A society in which men recognize no check upon their freedom soon becomes a society where freedom is the possession of only a savage few. Indeed, a society that does not understand how its government works and is thereby prepared to defend its principles and institutions becomes a society in which freedom and liberty becomes the possession of a savage few. At present, there's a fundamental distrust in our institutions and the very framework of society. As of 2022, only 2 in 10 Americans trust the federal government to do what is right just about always or most of the time. In 1964, 8 out of 10 Americans had this trust in our federal government. Lack of civics knowledge also decreases people's support for democracy and instead exponentially increases support for totalitarianism. In a recent study of citizens of Australia and the United Kingdom, researchers found this. In Australia, those who could not define democracy were more than 2 times more likely to support authoritarianism. Furthermore, 26% of Australians who could not define democracy supported military rule. In the United Kingdom, 1/3 of citizens who could not define democracy supported authoritarianism, with 28% of these same individuals supporting military rule. The situation in America mirrors that of Australia and the UK. In the past 30 years, the proportion of Americans who believe it would be good or very good for the Army to rule our country has soared from 1 in 16 to 1 in 6. 1 in 4 Americans say violence against the government is sometimes okay. In a CBS poll conducted 2 weeks ago, 72% of Americans believe democracy and the rule of law are under threat. I'm actually somewhat encouraged that the fragility of our democracy is being acknowledged. At the annual meeting of the American Law Institute on May 20, 2019, then Justice Anthony Kennedy said this, "Democracy presumes that there will be a consensus based on thoughtful debate." He went on, "Plato and Aristotle gave a low grade to democracy because they thought democracy did not have the capacity to mature." Justice Kennedy concluded, "Today we are not proving them wrong." But these words were spoken in May of 2019, a year and a half before January 6, 2021. So what can we do to bolt down the armor of democracy, to stem its erosion and restore confidence in our institutions of government? First, we must address the civics crisis. Jefferson said, "An educated citizen is a vital requisite for survival as a free people." Franklin Roosevelt said pointedly, "Democracy cannot succeed unless those who express their choices are prepared to choose wisely." The real safeguard of democracy, therefore, is education. The United States, despite its current challenges and the divisions among our peoples, is still the beacon of freedom, liberty, and opportunity for the world. Our system is not always perfect in its application. It does indeed falter. But if we work to preserve and strengthen the rule of law, we will remain that beacon. Indeed, we must. In the words of then American Bar Association President and later Supreme Court Justice Lewis Powell, he said this: "The only viable alternative to the rule of force is the rule of law." You can make a difference. You can make a difference. With knowledge, you can become advocates for the protection and preservation of the rule of law. Wofford is one of the premier academic institutions in the nation. You have virtually unlimited access to amazing and knowledgeable faculty. Your learning here can help you promote stronger rule of law and a more vibrant and participatory democracy. Every single person here can be part of the solution. You are the future leaders of our nation. Several years ago, I had a meeting in Washington which was canceled, so I had a chance to take a run around the National Mall. It was one of those picture-perfect early fall days with a crystal blue sky. And I got a little lost on my run, and I came into the back way of the Martin Luther King Memorial, and I needed a rest. So I took some time there, and I gazed at the 450 feet long granite wall that marks the monument. And the wall contains 15 quotes in all, going from left to right. I observed the first quote on the far left of the wall, and you're all familiar with this one. "The arc of the moral universe is long, but it bends towards justice." The last quote on the far right quotes these words of Dr. King: "True peace is not merely the absence of tension, it is the presence of justice." The ultimate aim of our nation's government is justice. The preamble to our Constitution gives us a clarion call. We, the people of the United States, in order to form a more perfect union, establish justice. Justice is the first priority of our nation as set forth in the Constitution. The work of justice is hard work. It is good work, and it is work worth doing. I encourage you to embrace the work of justice in your daily lives, in the way you treat others, respect others, and care for others. For that is the spirit upon which the rule of law and democracy is founded. That is indeed, in the words of Judge Learned Hand, the true spirit of liberty. Thank you very much for your attention. Thank you. Thank you, sir.
Thank you, Dean Hubbard.
Thank you.
As was mentioned earlier, my name's Don Coggins, and I am a federal district judge for District of South Carolina, and I sit here in Spartanburg, just a few blocks away on Magnolia Street in the Donald S. Russell Federal Building in United States Courthouse. And before I ask some questions of our distinguished guest today, I want to make just a couple of comments. The first is, I am not a Wofford alumnus, and I can only assume that the fact I have two children who are is the reason for my invitation today. But whatever the reason, I appreciate the opportunity to be here and participate with my good friend William in this process. The second thing is, Dean Hubbard talked about the importance of the role of justice and the importance of our citizenry having confidence in our justice system, that it does in fact follow the rule of law and does not depend on any type of undue influence, does not depend upon the identity of the parties, but rather the justice of their cause. We have court hearings in the federal courthouse over here about 1 or 2 days every week. For all of the students especially, I want to give you an invitation that if you would like to come and observe these court hearings, they are open to the public. That's another hallmark of our system, transparency of our justice system. I would love for you to come and join us, and you can contact my judicial assistant. Dr. Alvis knows how to contact us. We're also listed, to the extent that still is a thing anymore. Don't have phone books, but you can look us up online and call and just ask Karen when we have something scheduled. We also do about 4 or 5 naturalization ceremonies per year. That's a very important aspect of what I get to do as a federal judge. People who are new to our country, who are taking that last final step to become citizens, people who are doing that through an unbelievably hard process to achieve something that most of us take for granted just because of an accident of birth. And I would invite you to come and observe one of those as well. So, but enough about that. Dean Hubbard, you spoke today about the importance of our constitutional legacy, the fragility of our democracy, and the importance of the rule of law in our society. In your role as Dean of the Law School at the University of South Carolina, can you share with us some of the fundamental tenets of legal education that you hope to cultivate among your students that come to the law school there?
Thank you, Judge. The mission of the University of South Carolina School of Law is to develop lawyer leaders for their community, state, and nation. And we take that purpose and mission very seriously. It's not enough just to learn the law, the doctrinal pieces of law. You have to learn, we try to focus on the doctrinal learning, the skills development, the problem-solving development, and leadership skills. I actually teach a course in the spring semesters called Lawyers as Leaders, and we bring in outstanding leaders, not just from the legal profession, but from other disciplines as well, to help inculcate our students and help them develop their leadership skills, because people in communities look up to lawyers to help them solve their problems. I'll digress for just a moment. I didn't go to law school to be a trial lawyer. I went because when I grew up in Florence, South Carolina, at a time of integration to the schools and there was a potential for violence and unrest, the peacemakers, the people in the community who helped guide that community peacefully through that process, were the lawyers in the community. And that was the inspiration for my going to law school. And that's the kind of role I think lawyers can play. But all citizens can play those roles too. It's not just limited to lawyers. But in the law school, we specifically try to enhance those skills.
What are some of the biggest challenges that you see facing the future of legal education in our country?
Well, the cost of it is too high. We really do, try to hold down tuition, and we try to make sure that students don't graduate with any more debt than absolutely necessary, because debt limits your options. And we want our graduates to finish law school with as many options as possible. The last time I looked, I think about 10 out of the Fortune 50 companies, CEOs were lawyers. Lawyers run foundations. They engage in government. They do all sorts of things. The skills you develop are translatable to all sorts of different endeavors, whether or not you choose to practice law. And so the critical thinking skills, the writing skills, the advocacy skills that you develop in law school are translatable. So we work on those kinds of skills, but the cost factor is a challenge for us.
What are some of the ways that the cost factor can be mitigated for students of modest means who may have great talent but not a whole lot of assets?
Well, that's why I'm on the road about 2 days a week trying to raise money from donors. As the president knows, that's a part of the job of a dean or a president, is to try to get those scholarship dollars to help our students not have to incur any more debt than absolutely necessary.
And there are a number of scholarships.
There are a number of
at the law
scholarships,
school.
yes. And so please work hard. If you want to come to law school, work hard, get your grades up so you'll be eligible for one of these scholarships.
For undergraduate students who might be considering a career in the law, what is the most important advice about the law that you would give them today?
Well, I think you're in the position now where I hope you take advantage of this incredible faculty, and don't shy away from spending time with your faculty, talking to your faculty members, getting the extra attention that they can give you. Work on your critical reading skills, your critical thinking skills, and really work on your writing. One thing to succeed in law school, you have to be able to think critically, analyze situations, and write and advocate for a certain position, depending on the side of the case you're on.
All right. Well, let's switch gears for a moment, lest we be accused of turning this into a law school recruitment.
It is. I hope. I'd like to see about 50 of you next year.
Yeah, we've talked about how successful Wofford students are at the law school. I don't know how many of these students may know this, but there was a time about 20 or so years ago, around the turn of the century, where 3 of the 5 justices of the South Carolina Supreme Court were all Wofford grads. So that's pretty impressive
We'll
statistic.
currently judge all 5 Supreme Court justices, and all 9 judges on the South Carolina Court of Appeals are graduates of our law school.
That's right.
Little plug.
All right, well, let's switch gears a minute and talk about your time as president of the American Bar Association. A lot of people in our audience may not be familiar with that association and what all it does. Can you tell us a little bit about the ABA?
Yeah, there's several core functions of the ABA. Most relevant to me now is it's the accrediting body for law schools. And so there's a whole body of information that you have to provide to the American Bar Association. They come in with review teams to make sure you're providing an appropriate education and a high quality legal education. The ABA also promulgates the model rules of professional conduct that the states adopt in their codes of professional responsibility. And it also has a function as the entity that is since the Eisenhower years, 1953, I believe, President Eisenhower asked the American Bar Association to do evaluations of candidates or nominees for the federal bench based on their temperament, integrity, and competence. And so that function is another part of the ABA. But the ABA also has 18 sections and divisions, so that once you're in the ABA more broadly, you can be in the healthcare law section, the environmental section, real property section, so you can go and develop your leadership skills as well as talk to people and develop a network. But you learn a lot about your area of law, and you make lifelong friends. But it's the one organization that's still out there among all the lawyer organizations that's not siloed. Its policies are developed in the House of Delegates, which has about 550 members. And those 550 members, it's just like Congress. They represent state and local bars from around the country. So they come together twice a year and debate resolutions.
One of the roles of the ABA that you just mentioned that is somewhat near and dear to me, at least it has been in my recent past, is the role that the organization plays in vetting nominees to the federal court. Tell me what your thoughts are about the current state of that process.
I think the process still works very well. I was on the committee for 6 years, about 20 years ago, and then I chaired the committee in 2018, 2019. So again, this committee is comprised of 1 representative in each federal judicial circuit. We're in the 4th Circuit. And then when there's a nomination to the federal bench, that committee person contacts between 50 and 75 different people and gets input on the competence, integrity, and temperament of the nominee. And that information is then passed on to the Senate Judiciary Committee and to the White House. And so it's just another way of vetting candidates and providing the public with some additional information about the quality of the candidates. And I must say that I think you're going to ask me a question in a minute about the Senate process. Mm-hmm. I'll go ahead and preempt that if I will.
You go right ahead.
Because I'm leading
Talk about confirmation.
30 years ago or so, Justice Scalia and Justice Ginsburg were up at about the same time. Now they had different judicial philosophies, but both were approved by almost unanimous votes of the United States Senate. And what we've seen now is basically the votes come down almost always are close, in many cases, along party lines, which just is a further indication of kind of the division that we see in our country. However, there's one notable exception. This gentleman was approved by the Senate by a vote of 96-0, and he's in Spartanburg, South Carolina.
I don't know if that's a function of qualifications as much as it is that I was nominated by President Obama and then renominated by President Trump. So neither party, they would have embarrassed themselves by voting against me. So, with respect to the confirmation process, obviously, as you indicated from the way the voting has changed, it has become pretty politicized. How does that affect the ability of that process to work the way it was intended to work?
Well, I was reading some historical material last week, I believe, and there was a president early in the life of our country. I believe it was Chief Justice Marshall. I think he was nominated on a Monday and confirmed by the Senate on a Thursday. And now we have this elaborate, drawn-out process, some of which is necessary. You'd have to do the background checks. But when you look at these judicial proceedings now, just consider the most recent one, Ketanji Brown Jackson, or any of them, regardless of whether it's a nomination by a Democrat or Republican. In the last decade, 2 decades, there's too much political posturing in that process, too much of a politicization of that confirmation process, which my thought is that it really undermines people's confidence in the judiciary, because they translate that kind of politicization, believing then that the judges are political. So the process itself, it becomes overly politicized. It undermines people's confidence in the integrity and fairness of our judges. And regardless of who appoints those judges, in my experience, in court, they, almost to a person, our judges apply the law, they analyze the facts, and they apply the law, and they do everything they can to be fair. There are just so few exceptions among the federal bench in the United States of America. It just doesn't happen very much. But I don't think people trust the system because of this politicization in the confirmation process. I think it's undermined that.
Your view, as you expressed it there, calls to mind Chief Justice Roberts famously said, we don't have Obama judges, we don't have Trump judges, we have federal judges who try to follow the law. As we go forward, how do you see the future of the federal courts? Do you think that the federal courts will be able to maintain that aura of even-handedness that they have traditionally done, even in this age of very partisan division?
I think we'll come out of it. I think, we have to come out of this deep division and this distrust. And the more people actually experience the courts, so that's why I encourage all of you to take Judge Coggins up on his offer. Go to the courthouse, watch a hearing, look how carefully those processes take place and how hard these judges work to get it right. Somehow, the hard work of the courts has gotten lost in the political process, and so that's our role here, and all of you is to experience our government processes, to learn more about our government processes, and be proponents and help us restore trust in the institutions of government. They're not all corrupt. Government works pretty well. The government is the people. It's us. It's who we are. And so always attacking the courts or elected officials, it undermines it. One thing that's important to lawyers, and I say this at orientation to each year's 1L class, first year class. The preamble to the model rules of professional conduct and to the rules around in all states is that lawyers are, quote, public citizens with special responsibilities for the administration of justice and a strong responsibility to help maintain trust and confidence in the justice system. So lawyers who are out there, if they're out there disparaging the justice system and saying it's corrupt just because they lost, in every case, one side or the other loses. And so, we really need to make sure that, and we need to make sure that lawyers understand that role, and it's not appropriate to go out and criticize a court or a judge just because you lost.
Yeah, I had a judge who I respected very much. In fact, he was former Chief Justice of our South Carolina Supreme Court. When he was on the trial court, he used to have a saying. He told all the lawyers, if I rule against you, for 24 hours, you can cuss me, you can fuss about me, you can say whatever you want to, but after that, you better be quiet. Before we wrap things up this afternoon, I'm going to see if we have some questions from any of you folks. Dr. Alvis, do we have a few? Okay. All right. All right, Dean Hubbard, what do you think of proposals to change the structure of the current Supreme Court, such as adding more members to the court or imposing term limits on the justices?
I don't think, if you know your history, President Roosevelt in the 30s tried to expand the court, and it's just not appropriate in my judgment to try to change the structure of the court or add justices to it in order to promote a particular political agenda. So I have some I don't agree with that approach. I think, we've got a pretty good system. It sometimes falters, but I think when you start messing around with the structure of the court, I think you just open Pandora's box. I have a little bit different feelings maybe about how long a justice should serve. Maybe I do think they should have lifetime appointments, but at some time, is there an age limit by which it might be appropriate for a justice to step down? I'm still pretty open and would like to think about that a little bit more. Judges at your level can take senior status and still participate, but it makes way for other judges to come in, and that seems to work really well at the trial court level and at the appeals court level.
Well, and we have a mandatory retirement age for judges in our state system, although many of them can still serve by special designation after they have retired. In light of the time, I think we probably need to try to wrap this up. So let me just ask this last question. Given your years of experience in the legal profession, including your roles in private practice as president of the ABA and now as dean of the law school, would you still recommend a career in the law today?
Absolutely. I think it's a terminal degree. The skills you learn in law school are invaluable no matter what course or discipline or occupation or profession that you choose. And if you practice law, you have a lot of power to do well. You are a problem solver that people look up to. It gives you extra tools to be a leader. Lawyers need to be judicious about how they use that power, but you have subpoena power. You have the ability to call people in for depositions and put them under oath and try to get to the truth in a case. We have to be very careful to monitor the behavior of lawyers to make sure that there are no abuses of that power. But I wouldn't trade what I learned, how I learned, the skills the knowledge you gain and the skills, and the opportunities you can. Again, having a law degree is a terminal degree. You can be a college professor with a law degree. You can be the CEO of a corporation. You can run a foundation. You can teach school. You can be a lawyer. So to me, it opens up all sorts of doors, and the skills are translatable to anything you choose to do except perhaps surgery.
Yeah, we don't want any lawyers handling scalpels. Well, Dean Hubbard, thank you very much.
Thank you, Judge.
Appreciate you coming and being with us this afternoon. I'll ask everybody to join me in thanking Dean Hubbard one more time.
Thank you, sir. Appreciate it. That was great. Thank you.